Hello and welcome to another video by the A-level law teacher. Today we're going to be looking at the topic of offer and acceptance, which is one of the first topics of formation on the OCR A-level law specification and contract law unit. So in terms of the first bits of information, just really useful to cover what is a contract. So a contract is simply an agreement that the law will enforce. We make lots of agreements in life, but they're not necessarily enforceable in court. You might make an agreement with your friend or your family, but it's not necessarily enforceable in law. So it's not a contract. It's just an agreement, for instance. So a contract is an agreement that the law will enforce. Contract law is mainly made up of common law, and it's been developed over centuries. The principles have been built up for a very, very long time. And a 19th century definition of a contract describes it as a promise. So it's a promise to do something. And contract law is essentially based on being bound by what you promised and the need to do that. And we'll talk more about that later when we look at the evaluation of this topic. You are responsible once you make a promise as the other party is relying on it, and there's a really important principle of freedom of contract, which is the idea that you are free to agree with any party what you like and what you want that contract to look like. In terms of what you need to know for this topic, so you need to know the rules of offer and acceptance, the AO1 for instance. You need to know how to apply this to a scenario, the AO2, and you need to know the evaluation as this is an essay topic. More on what a contract is and the importance of offer and acceptance. So offer and acceptance is a really key part of the formation. To make a contract, you have to have offer and acceptance. We're going to be going through several things. So what is an offer? Who can make an offer? How long does an offer last? How does an offer end? What does acceptance look like? How can you accept an offer? And when does acceptance take place? And there's three sort of rules we're going to look at around that. In terms of starting with offer, and this video is very much going to start with offer and then finish with acceptance, so that's the sort of style and format we're going to go through. An offer is a statement of the terms upon which a person is prepared to be bound by a contract. So it's the terms that you're prepared to be bound by in a contract. The offeree is the person to whom an offer is made, and the offerer is the person who makes the offer to another. And it's important to know those and be really clear when you're looking at contract law who the offerer is and who the offeree is. And actually that can change even within the negotiation stage as to who's who. So you've got to be really careful you're clear as who is the offerer and who's the offeree. Once an offer is communicated to the offeree by the offerer, the offeree can choose to accept or not until such a time as the offer ends. So it's really important, again, you're clear on those two parties. First case on this, just to illustrate this, is Gibson v Manchester City Council, and it's the absolutely clear basic rule with offers is they have to be in definite terms. They can't be vague, they can't be like maybe, they've got to be like this is the terms that I'd be prepared to be bound by. So the council, in this case, the council wrote to Mr Gibson saying that they may be prepared to sell the council house to him, and if he was interested he should complete an application form. He completed the form, the council then said no, you can't buy it based off their sort of criteria. Mr Gibson said he took him to court and said that he'd accepted their offer, and that when they wrote to him that was an offer, but the court said it's not an offer, that wasn't an offer because it said may be prepared. They actually said that's something known as an invitation to treat. It's an invitation for him to make an offer to them. So, and the absolute key first thing with this is it's sometimes kind of like not quite clear who you think the offerer was. So in this case, you could be thinking, well, the council are making the offer to him, but actually they're making an invitation to treat. They're making an invitation for him to make an offer to them. So he is actually the offerer and they are the offeree in this case. So in terms of invitation to treat, you need to know a sort of couple of cases around this, and I've got a few areas here: advertisements, goods on a shop window, goods on a shop shelf, lots in an auction, requests for information, and then we'll look at the difference between sort of bilateral and unilateral contracts, which is quite important as well. So in terms of an advert, adverts are generally invitations to treat, not offers. So in this case, Partridge v Crittenden, he placed an advertisement stating Bramble-Finch cocks, Bramble-Finch hens, £1.25 each essentially. Now, there was a law that basically said offering for sale a wild bird was a criminal offence. So the question was he guilty of that? And the court held that this wasn't. He couldn't be guilty of that because he wasn't offering for sale. He was actually doing an invitation to treat. He was saying, this is the invitation, come and make me an offer. And someone would come along and say, I'd like to buy those, please, for £1.25. So they would be the offerer and he would be the offeree. And therefore, technically, and he did technically get away on a technicality here, because he wasn't technically offering them, he was an invitation to treat. So he avoided prosecution on that technicality. But that's a good example. An advertisement is a good example of an invitation to treat. Same with Fisher v Bell. So in this case, the defendant displayed a flick knife in a window with a price ticket clearly on it in a shop window, and he was charged with offering for sale a flick knife. And the same thing applied here. It was an invitation to treat. That knife in the shop window was an invitation for a customer to come in and say, I would like to buy that, please. So they are the offerer, and the shop is the offeree. So again, they weren't technically offering it for sale. Pharmaceutical Society of Great Britain v Boots. They were charged with selling controlled products without supervision of a pharmacist. They had stuff on their shelves. Now you had to then take that to the pharmacist and say, I'd like to buy it, please. So again, that's the key thing here, is it was an invitation to treat, not an offer again. So they weren't breaking the law. The idea was the customer could come up to the pharmacist, say, I'd like to buy this, please. They, of course, could say no if they're not allowed to buy that. So it was an invitation to treat again, not an offer. So stuff on the shelves is not an offer, which is kind of weird because often we'll talk about them in shops as being offers. Shops will describe them as offers, but they are invitations to treat. You are the offerer as the customer, and you go and say, I would like to buy this, please. For this amount of money, can I buy it? And the shop obviously can say yes or no. British Car Auctions v Wright. The auctioneer prosecuted for selling an unfit vehicle at an auction. Again, it was an invitation to treat. So the actual offerer was the person putting the bid, not them. They weren't offering it for sale. They were inviting people to make offers, inviting them to treat with them. So same situation here. It was an invitation to treat. The person making the bid would be the offerer. And finally, Harvey v Facey. So this was to do with the request for information. So in this case, Harvey wanted to buy Facey's farm. So he said, well, what would be the lowest price you'd sell it for? Facey replied saying £900, and that was just a reply to that request for information. Harvey then argued that Facey had made him an offer, so argued that that £900 was an offer, and then he tried to accept it. But the court said, no, the £900 was just a reply. That's an invitation to treat. It's an invitation for you to say, well, can I then buy that for £900, please? But that isn't an offer. Coming back with that, how much I would sell it for, is just an invitation for someone to treat with you and say, well, can I buy it for that, please? So again, sort of same principle there. In terms of bilateral and unilateral contracts, I'm going to keep this really, really, really simple. You could probably look at this in a much more depth and probably be explained in much better detail than I'm about to, but essentially, most commonly contracts are bilateral, so they're between two people or companies, bi meaning two, right, requiring both the offerer and the offeree to do something, and that's really important when we look at the topic of consideration. So both parties are required to do something. So goods for services is the really most common exchange in contracts, isn't it? A unilateral contract, these are all quite rare, only obliges one party to do something. So really sort of the main example of this is reward posters. So these are open to anyone. So I put up a reward poster and I say, well, if anybody finds my dog, I promise to pay them £100. So you listen to this video, you're not promising to find my dog. It's not a bilateral contract where you're going to find my dog and I promise to pay you £100 and you're promising to find the dog. That would be a bilateral contract. This is a unilateral contract because I'm the only person promising to do anything. Whereas if you find my dog, you can accept the offer, great, you can take the money, but you're not promising to find my dog. It's open to anybody. So that's a unilateral contract, and that can really clearly be seen in this case, Carlisle v Carbolic Smokeball. This is a really, really famous case that you do in contract law at university. It's one of the sort of key ones around contract law. The company advertised a smoke ball, and they said they would pay customers £100 if they used it and still got the flu. It was supposed to stop you getting the flu, essentially, if you waved it in your face. Mrs. Carlisle used it as instructed, but still got the flu, so she tried to argue she wanted the £100. The company said no, so she took them to court. And the company tried to argue that it wasn't an offer. But the court said, no, it is. It's a unilateral contract, just as we've just described. The offer was open to anyone that if they did happen to use it and they got the flu, they could claim that £100. So it was an offer that was able to be accepted by simply using it correctly, getting the flu, and then asking for that £100 reward, essentially. In terms of who can make an offer, so an offer can be made by anybody, any partnership, company, organisation. It can also be made through a notice or a machine, actually. So this was shown in the case of Thornton v Shoe Lane Parking. So Mr. Thornton put money into a machine and was given a ticket at the entrance to a car park. The offer was actually made by the machine, and he accepted that offer by putting the money in. So, and that's a really, there's a key thing there. The key difference with that is that there can't be an invitation to treat. It can't be, the machines can't do an invitation to treat. They can only do offers. So if you compare that with maybe a person, a booth, with someone in it taking parking payment, that actually isn't an offer. That's an invitation to treat, because it's an invitation for you to go up and say, I'd like to park here, please. And of course that person can say, no, you can't. Whereas a machine, it can't be an invitation to treat. It's only an offer, because when you go up to it, it can't say, no, you can't park here. So you accept that. So it's an offer, and you accept it by putting the money in. But if you went up to a booth with the person in, the difference is that would be an invitation to treat. You'd go up as the offerer, in fact, and say, I'd like to park here, please, and they of course could say no or yes. So actually, there's a clear difference between a machine and a person there in terms of who the offerer and offeree are, and it changes that dynamic there. So it's quite interesting. How long does an offer last for? So you can only accept an offer while it's open, and offers do close and can close. So you can obviously put a date on it or a time on it and say it'll shut at this point, in which case it does. And if the acceptance hasn't come before then generally there are certain difficulties with that, but generally then you can't accept it. And an offer only comes into existence once it's actually communicated to the offeree. So you have to actually, an offer doesn't become an offer until it's told to someone, essentially, which is kind of obvious. So communication requires the offeree to know the existence of that offer. So the key case on this is a case called Taylor v. Laird. He gave up, he was a captain on a ship, and he gave it up and whilst he was overseas, and he needed to get back to England. So he just decided to work as an ordinary crew member on the ship. He didn't ask anyone to do that. He just decided to do it to get the money and essentially to get back on the ship. But he then, when he got back, he received no wages, and so they didn't pay him. So he then took him to court and said, well, you need to pay me. And the ship owner said, well, no, I never had an offer for you to work as an ordinary crew member. You never offered that to us, and we never accepted it. So therefore, there's no contract. So there's no requirement for us to pay you your wages for that voyage. So, and the clear point then is that he should have told, I mean, the difficulty was it was 1856 and he was overseas, but he couldn't have perhaps. But in theory, the idea is he should have told them that he'd like to do that, he'd like to, and they could have, of course, said yes or no. How long, so how can an offer end? How can it come to an end? So there's 5 key ways here: revocation, rejection or a counteroffer, lapse of time, death, and acceptance. Let's just go through those. So revocation is where you revoke an offer. So if you make an offer and you actually change your mind, you can of course revoke it, and you can withdraw it at any time before acceptance. There's no restrictions on that really. As long as it's not been accepted, you can change your mind and revoke it. You have to communicate that revocation though. You can't just expect them to know it. You have to say, "This, I'm now revoking the offer. It's no longer, you can no longer accept it." So in Routledge v. Grant offered his house for sale and said the offer would be open for 6 weeks. He then changed his mind, no longer wished to sell the house, and he communicated with the other party and said, oh, I'm ending that offer, and that was it. And then the guy actually then tried to accept it afterwards and took him to court to say, well, I want to, you said it'd be open for 6 weeks. The court said, no, they revoked it. They told you they revoked it, so therefore you can't accept it, even though it was before the 6-week window. Dickinson v. Dodds shows the quite complication with this though. So Dodds offered to sell houses to Dickinson. He then revoked his offer, but he never actually told him in person. But a reliable person that was known to both parties did tell him that he'd withdrawn the offer. So the question was, well, is that enough? The fact that he didn't tell him himself, is that enough? And the court held, in this case, that it was effective revocation. That was enough because it was a reliable person known to both parties. So they did know. So it would be misleading. It wouldn't be fair for him to then try and accept the offer when he knows it has actually been withdrawn at that point. And the easiest way, of course, is to communicate directly. But so you might get a case like that, a situation like that, where it's sort of someone finding through from someone else, and you have to decide whether it's enough, as in Dickinson v. Dodds, or perhaps not. In terms of rejection and counteroffer, so once an offer is rejected, that offer is dead, so it's over. It can't then be accepted. So if you reject an offer, the person would need to re-offer it to you before you could accept it. So it's really, really important that you bear that in mind. If the offer is made to more than one person, rejection by one person doesn't stop someone else from accepting it though. and the rejection must be communicated to the offerer before it is effective. So a counter offer. So if someone offers to sell you a computer for £500, and you go, no, not 500. What about 400 or 400? You've rejected that offer. So by making a counter offer, you've rejected that original offer. And what happens is you're actually flipping the roles, because actually what you're now doing is you're making the offer. So you've become the offerer, and you're making the offer now, saying, well, would you accept this? So it flips the roles. And so you could actually flip roles several times in the negotiation stages as to who the offerer and who the offeree is. And you can see that in Hyde v Wrench. So Wrench offered to sell his farm for £1,000 to Hyde. Hyde then replied with a counter offer of £950. So he's rejected that original offer, and now he's become the offerer. Wrench then rejected that counter offer, and Hyde then tried to saying, well, okay, what about £1,000 then? And the other guy said no. And he then took him to court and said, well, no, you originally offered me £1,000, you've got to accept that. But because he rejected that original £1,000 offer, that's gone. So because he rejected it by making a counter offer, that's gone. So he can't then choose to go back to it. Now, someone might accept that. They're perfectly welcome to do that. But in this case, he didn't, and he couldn't go back to it. So if you have to be really careful. If you make a counter offer, you are technically rejecting the initial offer. Lapse of time. Offers don't last forever, so it's not all offers will have an end time limit on them, but they will lapse after a reasonable amount of time, and that's the key word there, a reasonable amount of time. That will of course vary according to the nature of the offer. The more if it's like food and things, it's obviously not going to be very long, because of course it'll go off, but property and the selling of property and stuff might be longer perhaps. And you can see that in Ramsgate Victoria Hotel v Montefiore. So on the 8th of June, Montefiore had offered to buy shares at a fixed price in the hotel. He hadn't had a reply. 23rd of November, his offer was accepted, but at that point, he no longer wanted them as the price share had fallen, and so he refused to pay it. And it was held that the long delay between the offer and acceptance meant that the offer had actually lapsed, so it couldn't actually be accepted at that point. So those several months there, it was too long. So offers don't stay open forever. It's a reasonable amount of time. Death. So if somebody dies, either the offerer or the offeree, it does affect whether that offer is still open. So if the offerer dies, the acceptance can still take place until the offeree actually knows. As soon as the offeree's heard that they're dead, then actually it can't take place anymore. But actually, if they didn't know, they can still accept it, which is kind of quite weird, unless it's to perform a personal service, in which case obviously the person's dead, so they can't. So a good example of that would be like tutoring a child. Obviously they can't tutor the child anymore because they're dead, so you can't accept it. You can't just expect someone in their family who's now inheriting their estate to do that. So the offer ends as soon as you find out they're dead, but you can accept it if you didn't know they're dead, as long as it's not a personal service. If the offeree dies, then the offer ends, and those dealing with that's it. So if the offeree dies, so the offerer has made an offer to the offeree then dies before accepting it. That's it, it's over. They can't, the family that inherit the estate, they can't accept it on their behalf. But they could make a new offer back to the offerer to try and then accept, to say, well, actually, will you now? But then it flips the roles. So, but otherwise, it's over. Acceptance, of course, would end an offer in terms of then moving forward to creating a legally binding contract. In terms of acceptance, so acceptance has to be positive and unqualified. So what I mean by that is you have to basically say, yes, I accept the terms exactly as you've put them. If you try and alter the terms, if you go yes but or yes if, that's a counter offer. And as we know from counter offers, that then ends the offer and you're just flipping roles. So if you think about that I agree button on websites for terms and conditions, you can't pick and choose. You accept all the terms or nothing, and that's the key thing of acceptance. You can't try and change the terms, otherwise that's a counteroffer. That's not acceptance. How do you accept an offer? So the offer, as we said, has to be unqualified and it has to be communicated. You have to tell them. Otherwise, again, same with offer. You have to tell the person. Otherwise, it's not acceptance. It doesn't have to be in the same format as the offer. So if someone's rung you and made you the offer, you could reply by email. It doesn't have to be in the same format. But acceptance can't be silence. There has to be a positive act. So in Feldhaus v Binley, there was discussions about the purchase of a horse. The final letter stated, if I hear no more, I consider the horse mine. There was no further response, but the court held that there was no contract, as an offer could not be accepted by silence or inactivity. So it has to be you have to actually say yes, I accept your offer, essentially, in some format. The general rule is that acceptance has to take place, acceptance takes place when the acceptance is communicated to the offerer, and that's a general rule which we're going to look at. There are three general ways of accepting an offer. So through your conduct, so doing something, through post, and there's specific postal rules around that, and then through electronic method, so an email or something like that. In terms of acceptance by conduct, obviously you saw that in the case of Carlisle v Carbolic Smokeball. So that's the case where she accepted the offer of that £100 reward by using the smokeball and it not working and getting the flu. So that's by that conduct of using the smokeball and getting the flu, she accepted the offer. We can also see it in the case of Reveal Independent LLC v Anatech International, quite a long case name there. Reveal agreed to basically promote products in some episodes of the US season 2 of MasterChef. And they were going to use some product placement. There was a written offer document which stated that it was not binding until signed by both parties. The offeree made some alterations to it, which essentially amounts to a counteroffer, and signed the document, but it was never actually signed by the offerer. But what they then went on to do was actually do it. So they actually filmed the episodes using the stuff and released these episodes essentially with the products in them. So the promotions took place, but the document was actually unsigned technically. And the court held that the counteroffer had actually been accepted by the fact that they went ahead and did what the conduct. They actually did do the product placement. So therefore acceptance did take place. So it's quite a confusing case, but essentially the point of this is if you go ahead and do the thing that you're saying you're going to do, that can be acceptance. You don't necessarily have to write back and go, yes, I accept it. If you do the thing, then actually that can be enough. Acceptance by post, obviously this is quite old now, but these have been developed in the sort of 19th century to deal with a problem where a contract came into existence where perhaps a letter's not been delivered correctly and whether the acceptance has taken place or not. So the rule also adapted the idea that once you post a letter, you can't get it back. So the rule basically only applies to letters of acceptance, so not to offers and counteroffers, so it's just an acceptance letter. And the rules are that the rule only applies if post is the usual expected means of communication, so it's normal method, and that's how you would do it, you're posting it. You have to be able to prove that the letter was properly addressed and stamped, and the offeree must be able to prove that the letter was actually posted, perhaps with a receipt or proof of postage. Now, if these rules are met, then actually acceptance takes place the moment you post the letter. Now, remember, the normal rule for acceptance is it's once it's communicated. So once the offerer sees the acceptance and goes, lovely, great, I can see they've accepted the offer. The difference with this one, postal rules, is that acceptance takes place the moment you post it. Now, the problem for that, of course, is the offerer, it might be weeks until that letter turns up, or if it gets lost, they might not even know that the offer's been accepted. But that is the rule. So it's quite harsh on the offerer, but quite nice for the offeree in the fact that they've clearly accepted it the moment they put that letter in. Key case on that is Adams v Lindsell, and you can see the problem here. Lindsell wrote to Adams offering to sell some wool and asking for a reply in post, so it's the normal process there, so it's one of the key rules. The letter was delayed in the post. On receiving the letter, Adams then posted a letter of acceptance the same day. But because of the delay, Lindsell assumed Adams didn't want the wool and sold it to someone else. However, there was a valid contract because acceptance took place as soon as the letter was placed. That acceptance letter was placed in the post box, and there had been no communication or revoke of the offer. So that case established the postal rules, and there's a really key case you need to know to back up, and you need to include around the postal rules. In terms of electronic methods of communication, the laws struggled to deal with this, to be honest, because it's different, very different to postal rules. It's much more instant in most cases. And the principle generally is that acceptance, apart from the postal rules, is that it occurs when the offerer is made aware of the acceptance. So the offerer is made aware of the acceptance. You can see that really clearly in the case of Entors v Miles Far East. And Lord Denning said, if a man shouts an offer to a man across a river, but the reply is not heard because of a plane flying overhead, there's no contract. The offeree must wait and then shout back his acceptance so the offerer can hear. So the emphasis there is the offerer has to know that acceptance has taken place. Key case on this is Brinky-Bond v Stahag Stahl, which dealt with the problem of out-of-hours messages, and these are only effective once the office is reopened. So in that case, if you sent an email in the middle of the night, that email acceptance would take place the moment the office opens the next day. So not the moment you send it, but the moment the office opens the next day at the office hours. Consumer protection, distance selling regulations give consumers a number of rights in addition to those within the Consumer Rights Act. And Article 11 of the Electronic Commerce Regulations stipulates some stuff around acceptance where a buyer is required to give his consent through technological means, so basically clicking, so doing it, but buying something online. And the contract is made when the buyer has received from the service provider an acknowledgement of receipt of acceptance. So how this works is, if you think about most online businesses, they say your order's been received, they don't, and being processed. They don't say accepted. That usually comes as a second email if you think about like Amazon and things. So it gives them the opportunity to still withdraw. So when it says it being processed, if they then realise they haven't got it, they can still withdraw it and say, actually, no, your offer's your acceptance can't, this order's cancelled essentially. But once you get your order has been accepted email, that then means that you have a contract at that point that's been accepted. So really key bit of sort of electronic methods there. In terms of scenarios for this then, so it's really important you read the question carefully. What's the focus? Is it offer or is it acceptance or is it both? And then what you need to be able to do is apply the relevant rules and content. So not all of that is going to be relevant. Someone might not have died, for instance. There might be no issues with post. It could be they're going to choose certain bits. So it's really important you reach a conclusion answering the question as to whether an offer was made or accepted or both. And you need to go through methodically the rules. And the absolute really clear here is that you are really clear who the offerer and who the offeree is. And I always find the easiest thing to do here is just to write out a narrative of what happened from the beginning to the end, who's who did what, and essentially has, through that narrative, has offer and has acceptance taken place. In terms of A3, this is an essay topic, so I'm just going to go through some key jumping off points here for you that you could talk about and develop. One of the key massive problems is this distinction between an offer and invitation to treat, which is really confusing, and actually most lay people wouldn't recognise it as that. You talk about offers in shops, so actually it's not really very clear, so it's a massive confusing area, and the difference can be very slight, and actually technicality, if you think about cases like Fisher v Bell, where they clearly were offering for sale that flick knife, but because it's not technically an offer for sale under contract law, then they got away with it. And there's clearly a massive disparity between law and practice there. As we said, shops call them offers, buy one get one free offer, but it's not actually an offer. So it's really important that that's covered. One of the other really important things there is freedom of contract. So in Fisher v Bell, you might see that justification as quite pedantic or stupid, but it is based on freedom of contract. If the shop window display was an offer, so let's just imagine that was an offer, not an invitation to treat, then that would remove the shop owner's right to decide whether to actually sell it to the customer or not. Because what would happen if it was an offer? All that needs to happen is the customer comes in and say, I accept your offer to buy that knife, and that's it. The shop would have to sell it to the customer. Whereas what actually happens is the customer comes in and says, I would like to buy that, please, and of course the shop owner can say yes or no. So if they were offers, if all the things in shops were offers, shops would never have the ability to say no to people, and that would remove their freedom of contract, because they wouldn't know what customer was going to come in or not, so they'd have to sell it to whichever customer appeared, which would remove that freedom of contract, which is a really important principle. So therefore we have to have them as invitations to treat, otherwise you wouldn't have freedom of contract. Also, if you think about selling prohibited goods, so like knives or alcohol, they would be in breach of that, wouldn't they? Because they'd be making offers to children or to people that can't, and a child would come in and say, I accept your offer to buy that knife then, and that'd be it. They'd have to technically then sell it to them because they're in a contract, but surely they that's not the case. Although you could imagine that could be sorted through legislation by saying, well, clearly what an offer looks like in practice, but they've not done that, and actually we retain this invitation to treat method. Goods on a shop shelf. So in a self-service shop, people generally believe that goods can be bought there and then, or at least brought from the storeroom to the shop floor, and that you have a right to take it and that you have a right to be sold it. If goods are not in stock, though, the customer believes that the seller will be able to provide them perhaps at a later date. So it's been suggested that invitation to treat should be treated as offers, so that the law would mirror the public's belief in this situation, that that's what it is. And if an item on a shop shelf had the same status of an offer, though, then once the item has been placed in the shopper's basket, a contract would arguably be made, and a customer would be bound to pay for it and buy that, and they wouldn't be able to change their mind, or they'd be in breach of contract. So if there was a pricing error, for instance, it would be too late, as the contract would always be formed. So purely from a practical point for shops, it's really important that they're not offers, that it is actually invitations to treat. So if there's a pricing area, they can correct it. If they haven't got anything, if they haven't got the stock, they can correct it. They can say, well, I can't sell that to you. So and they're not inbound contracts. There is a lot of legislation around misleading advertisements, which obviously are a problem, which suggests that these advertisements only have legal significance if they lead to a contract. So whilst legislation leads to criminal sanctions, the individual affected by the advertisement is usually only left with a claim of misrepresentation, which is a topic we'll look at later on the course, unless some part of the advertisement has become a term of a contract or there is protection under the Consumer Rights Act. The only remaining value of cases like Carlisle is genuine reward cases, so those unilateral cases are quite rare. So the missing cat, £100 reward things. So quite a complicated bit of AO3 that, but something you could definitely include. In terms of the duration of the offer or the sort of information or counter offer, it's again really confusing as to exactly who and what forms an offer and how long it remains open. There's many ways an offer can end, which obviously creates difficulties and uncertainty. And a counter offer ends the original offer, but it's not clear what exactly constitutes a counter offer and how a counter offer differs significantly from a request for information. So you can see that in the case of Stevenson v McLean, for instance, with the inquiry about credit. How was that not a counteroffer? So the fact that counteroffers switch the roles, is that really the case? That again, that creates some confusion there. And when you're creating uncertainty in the law, that's obviously going to be difficult for legal professionals to advise their clients, meaning more money, more time in courts and things like that. How long is a reasonable time? So obviously we know that offers stay open for a reasonable amount of time, but obviously that's very subjective, and it offers to people that the good thing is for offerers, it gives them the ability to change their mind, which is important. Gives the freedom of contract again, is their ability to say, no, actually I don't want to contract with you anymore, so I'm going to change my mind, I'm revoking the offer. But we know this reasonable time thing, it's not very clear. So, and it varies enormously, largely on what's morally right versus losing money, which is often really a poor choice for businesses. In terms of problems with counteroffers, I sort of talked about this already, but a counteroffer ends the original offer or order, and this may take place on several occasions during negotiations. This seems to be fair, as an attempt to go back to the original offer, is rarely refused, to be honest, in negotiations. The price rarely goes up, so you rarely would go back to the original offer, but you could make that offer still, but it still seems a bit weird that you wouldn't have the right to do that. Silence. In Fethouse v Binley, both parties wanted there to be a contract. We know that actually both parties wanted there to be a contract in that case, actually, if you look at the facts. But the court said that from an objective viewpoint, there was no evidence of acceptance from the nephew. The nephew had actually contacted the auctioneer holding the horse to remove it from auction, which would contradict that view, actually. But there was no evidence really, and the silence wasn't enough. So for the court to decide there is a valid contract, there has to be clear and identifiable evidence. The offer has to be communicated, and so logically must be acceptance. But if you compare that with cases like acceptance by performance, there's a massive bit of inconsistency there. So in Revel v Anatech, they never actually said yes, but their conduct was enough. So again, there's a bit of inconsistency. That's a really nice point you can make there around contradictory bits of law. Postal rules, these are a bit of a mess. They're really unfair on the offerer, who may never actually even receive a letter of acceptance or definitely get it late. And the offerer is party to a legally binding contract without perhaps even realising it. The offerer may have contracted with another party by that point, which means they're then in breach, so that's not very satisfactory for them. But it's not really their fault or anyone's fault, so it's quite harsh. Entors and Brinkley Bond suggest that courts are not willing to expand those rules of acceptance, so being when you send it, to forms of communication. So, and largely because they believe an offeree should take reasonable steps to ensure the acceptance has actually been received. And it's much easier with electronic methods of communication, and of course they're much more instant. So we're kind of moving away from postal rules because they are largely outdated and should probably be restricted in a way, because, as I said, we're moving towards we're in the world now of much instant communication methods. You haven't got to wait weeks for a letter to arrive. In terms of those modern methods of communication, if the obligations with respect to providing key information to the consumer are omitted, then no contract is formed. So if you miss key information out for a consumer, then there's no contract. However, the seller may still have received payment, and it may be difficult to regain that payment under the non-existent contract. So once you've submitted your money to Amazon, for instance, or another company, they might say, well, actually, we haven't got an offer, we're not processing your order, but then they might retain your money, and you might not get it back for quite some time, which is actually quite naughty because there's no contract. So they should refund it instantly, but they don't in most cases. Article 11 of the regulation sets out when acceptance takes place, hence the wording many online businesses use, so they're all very consistent because of that. But when do they actually accept the order? When can you have your money back? That's kind of what we've been saying there. So hope that you found that useful. Just going back to one point on that actually, in terms of reform that's not included on there. Obviously, one of the key areas here is there has been a lot of reform through Consumer Rights Act and things like that. But one of the key areas is that all of this is common law practically. Most of the rules of offer and acceptance are common law. So one perhaps suggestion for reform is that this could be legislated, a statute could be created laying out really clearly from Parliament the rules of offer and acceptance, but that's quite unlikely. That's never happened, and I would think quite unlikely. So I hope you found that video useful. Please subscribe to the A-Level Law Teacher on YouTube for more videos soon. Thank you very much.